evening to join us in this presentation. This is it's a little bit different for us. It seems like the entire world's turning into one big Zoom meeting, and I feel like I'm the weatherman with all this digital shadow behind me. But nonetheless, thank you for joining us, and hopefully there's some value to what we present to you this evening. I really enjoy getting out across Pennsylvania and meeting with landowners and talking about oil and gas issues. But the COVID-19 has limited our ability to do that. And so we can't do a traditional meeting. And so now we're here virtually. I think we're having a little bit of a technical problem. Can you still see me?
No.
I'm back. There I am. All right. Again, this is we're here virtually, and hopefully we can pull it off without any more glitches. COVID-19 has also, it's impacted our daily routines. It's changed our lives, but oil and gas law is still evolving and changing. Cases are still being decided, and these cases can and will impact your oil and gas lease. So tonight we're going to talk about three topics that were germane to 2020, but I think you're going to stay with us, and they're going to be part of 2021 and beyond. Three topics. Number one, hydraulic fracturing and subsurface trespass. We had the big Briggs decision back in January, and I wanted to elaborate on some developments that happened late in the year. Second topic is going to be deduction of post-production costs. This is an issue that has been around for several years. It's not going anywhere. We had some cases from other jurisdictions that I think might foreshadow trends and different trajectories here in Pennsylvania in 2021. And then finally, third topic is the consent to assign clauses. This is an issue that I believe in 2021 we're going to see more of with all the impact from COVID-19 and bankruptcies and the shuffling and trading of leases. Many of you landowners are going to be asked whether you consent to an assignment of your lease. And there's not a lot of guidance here in Pennsylvania on that particular issue. And there was a case last year from Texas that I think will inform the Pennsylvania courts if this issue comes up, which I'm sure it will. So let's go on to the first topic, hydraulic fracturing and subsurface trespass. As many of you know, back in January, the Supreme Court issued the much-awaited Briggs decision. And this case, was probably the most significant oil and gas decision that was rendered anywhere in the country. And it has to do with the interplay between hydraulic fracturing, subsurface trespass, and a rule of law known as the rule of capture. And as the slide indicates, there was a lot on the line here. There was a lot that was both landowners were concerned as well as drillers were concerned of which way the court was going to go. And as we've talked in our prior presentations, the Supreme Court, I think, got it right. And it gave a little bit to both sides and provided the clarity that everybody was looking for. Next slide. But you might be asking yourself, all right, Burnett, that was a January decision. Why are you talking about that and the impact it's going to have in 2021? Well, this slide gives you a little bit of a clue. See that little Roman numeral 2 next to Southwestern Energy? There was a significant development in December of last year with respect to Briggs and this notion of subsurface trespass. And that's what we're going to really talk about tonight, is where the Briggs model and where it's going to go in 2021. But before we get there, let's talk about what happened in Briggs. Briggs he still owns a 11.7 acre parcel in Susquehanna County, and it was unleased. On either side of his parcel, Southwestern had taken oil and gas leases and had included those adjacent parcels into two different units and drilled horizontal well bores. One of the well bores passed very close to the boundary of Mr. Briggs' property. Next slide. He alleged in a complaint that was filed in 2015 that Southwestern was unlawfully extracting natural gas from beneath his property. What's important is he did not allege that the lateral actually passed underneath his property. He just said the hydraulic fracturing that's taking place on the adjacent parcel is too close, and it must be draining hydrocarbons from my unleased parcel. Southwestern defended, in part, on the grounds that the Briggs claims were barred by the rule of capture, which I'm going to get into in a moment. The trial court agreed with Southwestern and held that the rule of capture operated as a absolute affirmative defense that barred the entire claim. An appeal was subsequently taken from that trial court decision. But before we get into the procedural history of the Superior Court and then the Supreme Court, and then what happened in December, let's just talk briefly about the rule of capture, because this is the centerpiece of the Briggs enigma going forward. The rule of capture is a principle of oil and gas law that was developed here in Pennsylvania back in the 1880s. It's literally that old. And basically what it says is that if you lawfully drill a well into a common reservoir, the natural occurrence of gas going from a high pressure area to a low pressure area is going to drain the gas to that well location. The best example that I can give of the rule of capture and how it applies is, imagine a checkerboard or a chessboard, and you have black and white squares. And imagine on that checkerboard, if you drill a well in the center black square, and the well goes straight down into the common reservoir. The board itself, the checkerboard, is the common reservoir. You drill a well from your least black square into that reservoir, it's going to drain gas from all of the area represented by the checkerboard. So all those individual squares, whether they're black or white, are separate parcels. The oil and gas from underneath those parcels is going to drain to that center well. And even though the operator of that well may not have a lease for each and every square on that checkerboard, the rule of capture says that's okay. The gas is going to drain from high pressure to low pressure, and we're not going to hold that operator liable for gas that drains from that common reservoir. Next slide. Now, what happened, the trial court ruled in favor of Southwestern, and Briggs filed an appeal. And on appeal, the arguments that were being advanced were sound. Essentially, the theory was this, that when you look at well casing, it serves the same purpose, essentially, as hydraulic fracturing and the fissures that are created by the hydraulic fracturing operation. When an operator fracks a rock formation, whether vertically or horizontally, it's shooting fluid into the wellbore area that flows out into microscopic cracks in the rock, fissures. And in those fissures, the operator puts, again, at a micro level, propants, little pieces of sand that hold open the frac fissures. So in a sense, the propants serve the same operational purpose as the casing itself. They create a pathway that allows hydrocarbons to flow out of the rock into a vessel and up to the surface. So the argument before the Superior Court, and essentially the Superior Court's decision, was that the act of hydraulic fracturing a shale formation creates an artificial reservoir, and that the gas then flows out of that artificial reservoir into the wellbore. That is the rule of capture shouldn't apply. It's a trespass. An important caveat to all this is the rule of capture does not apply if the wellbore is a deviated wellbore. Going back to our checkerboard example, if the wellbore, instead of going straight down and staying within the four corners of that black square, deviates at the bottom and bottoms out underneath someone else's square, the rule of capture doesn't apply. Never has. It's not disputed. So using that by analogy, the argument was that the frac fissures extend the wellbore beyond the lease boundaries into an unleased parcel. So because it's an artificial reservoir created by the frac fissures, the rule of capture shouldn't apply. Go back to the same, one more, go back to that slide, Brendan, please. So the Superior Court reversed the trial court, but on appeal to the Supreme Court vacated the Superior Court's decision. That's a decision back on January 22nd, 2022. And it sent the case back to the Superior Court to conduct further proceedings. And the Supreme Court basically said this distinction between artificial and naturally occurring reservoirs or stimulation is invalid. The Superior Court issued a remand opinion this past December. Next slide. Before I get into exactly what the Superior Court said, I want to make it crystal clear that what the Supreme Court said remains in effect. That the rule of capture still applies. It didn't get rid of the rule of capture. But with respect to hydraulic fracturing, there isn't an absolute per se rule. Superior Court was saying if you use hydraulic fracturing, there's a per se rule that there must be some type of physical invasion via the propens and a trespass occurred. The Supreme Court rejected that per se rule and said, next slide. Well, before I get, the Supreme Court said that you have to demonstrate and allege a physical invasion. It's not, there is no automatic, because you use hydraulic fracturing, we're going to assume that a trespass occurred. The plaintiff has to plead and allege and ultimately prove that the operator actually injected propens through the hydraulic fracturing process into the unleased parcel. That's a pretty steep burden, but that's always been my understanding of what the law required of a plaintiff anyways. We have to demonstrate that the fracking process, as a result of the fracking process, the driller injected and put the actual propens in the frac fissures under my property. That's a trespass. So what happened in December? Next slide. On December 8th, 2020, the Pennsylvania Superior Court. Now that, again, if you imagine a court system, we have the trial court, then the Superior Court, and then the Supreme Court. The Supreme Court set the matter back down to the intermediate Superior Court, and the Superior Court took a second look at the Briggs complaint and the record that was before the court. And the Superior Court actually determined that it made a mistake in light of the new Supreme Court guidance, and it threw a curveball. It affirmed the original trial court's decision to grant Southwestern's motion to dismiss the complaint. Yeah. So after all this, the Superior Court determines that Mr. Briggs loses in this case. What the Superior Court determined was that the original complaint did not allege sufficient facts of a physical invasion. In other words, the complaint just merely alleged that a trespass was occurring because of hydraulic fracturing. And the Superior Court said, you know what? In light of what the Supreme Court has told us in its January 22nd, 2020 opinion, this isn't enough. And the Briggs complaint fails to meet this new standard. You have to allege an actual physical invasion or intrusion by virtue of the hydraulic fracking operations. Next slide. But here's the big takeaway from this Briggs decision, the Briggs II decision. Frac trespass is and remains a viable cause of action in Pennsylvania. That did not change. What has changed or has been clarified is you have to allege some factual basis that the driller committed a physical intrusion into your oil and gas estate. This means in the complaint itself, you're going to have to allege that specific facts, that the problematic wellbore is located within 300 feet or so of the property boundary, that the fracking operations that took place on so-and-so date injected volumes of hydraulic fluid that contained propens, and those propens were injected into the property, underneath my property, and are still there, and they are propping open the frac fissures and allowing hydrocarbons to flow out. It seems like a steep burden, but and I think Brendan would agree with me that we've always viewed that as the actual burden that a plaintiff would have to demonstrate anyways. So again, Briggs is still good law. Frac trespass can be alleged and Claims can be brought under that theory here in Pennsylvania. You just have to be careful about the way you plead the claim in the original complaint to allege an actual physical intrusion into your oil and gas estate. Next slide. We're going to pivot slightly and move into a topic that, again, has been part of Pennsylvania oil and gas law for the last 10 years and will probably remain so for the next 50. And that's the deduction of post-production costs. Many of you that are joining us this evening, you get royalty statements, and probably every month when you open that royalty statement and you see those deductions, you get irritated and you get upset because the language of the lease may authorize deductions, and these drillers, they love to take deductions. Now, the two cases we're going to talk about that I believe are going to have some, or may have some effect here in Pennsylvania are Bluestone Natural Resources and also Young versus Ecuador, USA. Neither case is actually from Pennsylvania, but I believe these decisions may reflect a swinging of the pendulum, so to speak, towards drillers and a broader right to take deductions than we've seen over the last couple of years. You know, after Kilmer was decided years ago, the pendulum certainly swung in the direction of drillers. But then I noticed because of advocacy and getting cases before judges and arbitration panels, the pendulum started to swing back towards landowners and a more equitable and careful review of actual royalty clauses. In light of Bluestone and Young, although it's a small sample size, it may reflect a trend going the other direction, where courts are now looking for any type of hook or angle that would authorize the deduction of post-production costs. So let's go and talk about Bluestone. Next slide. Bluestone is a case out of Texas, and at issue in this matter was a 1986 mineral deed that contained language that the plaintiff believed prohibited the deduction of post-production costs. It said 1/8 of gross production delivered to grantor's credit free of cost in the pipeline. And that phrase, free of cost, to the plaintiff meant, hey, this is a gross royalty. And there were some other cases in Texas that, you know, attach legal significance to that phrase, free of cost. However, in this matter, Bluestone was deducting costs that were incurred downstream from the intake meter of the gathering system. In other words, there was a well pad, and downstream from that well pad, there was a flow line that connected to the gathering system. And at that meter location, from that point downstream, Bluestone deducted gathering, compression, dehydration, and transportation costs. Next slide. Engler argued that that was improper, that given the express language in that deed, the royalty valuation point should be the point of sale on the interstate pipeline network. That's where the gas was being sold. That's where you should be valuing my royalty, and you shouldn't be valuing the royalty at the intake meter of the gathering system and deducting costs from there. Engler further argued, and I thought it was a novel argument, that a gathering system itself is not a pipeline. It's a series of pipelines and infrastructure that are used to treat and move the gas to the ultimate sales marketplace, the interstate pipeline. And so Engler argued that, well, because I believe you should be valuing my royalty on the interstate pipeline network, that's where you sell and market my gas anyways, it's disingenuous to call the gathering system a pipeline and then use that as the royalty valuation point. Third, Engler argued that, again, the phrase free of cost under Texas law meant a cost-free royalty. And it, regardless of the qualification of in the pipeline, free of cost means free of cost. You can't deduct anything. Next slide. The court rejected the plaintiff's arguments and argued and opined that the phrase in the pipeline was the equivalent of a valuation point at the wellhead. And as many of you are aware on this online tonight, at the wellhead has legal significance, not only in Texas, but here in Pennsylvania. If your lease has language that says at the wellhead, it is essentially, as per Kilmer, it allows the operator to deduct costs incurred between the wellhead and the downstream point of sale. The argument being that in order to arrive at a wellhead value, the operator has to deduct out the intervening costs incurred between the wellhead and the downstream point of sale. So what the court did in Bluestone is significant. It's saying that we're going to treat in the pipeline language as the same as at the wellhead, and that's the location where the royalty should be valued. And in essence, it invited and approved the utilization of the netback method to deduct out the cost that Bluestone was incurring between that intake meter and the actual sales point on the interstate pipeline network. You know, what is alarming to me about Bluestone is it reflects some arguments that Brendan and I were seeing here in Pennsylvania, that some operators would argue to arbitration panels and to courts that, hey, Your Honor, or members of the board, we're not deducting any costs until the gas actually goes into the gathering system. We're not deducting any of the costs that are incurred on the well pad itself. You know, there are GPU units, there are dehydration units, separators, and those cost money to operate and to run. And we never charge the landowner for those costs. We only charge the costs that are incurred after the gas leaves the well pad and goes into a pipeline. So the theory that was espoused by Bluestone that in the pipeline should mean at the wellhead, we've already seen that germinating here in Pennsylvania. And I believe that in 2021, we're going to see more of this emphasis on in the pipeline language if it's in your lease. So be mindful of what your royalty clause says. There are some royalty addendums that we've seen that say, hey, no cost, or the royalty should be calculated free of cost into the pipeline. And for many years, landowners and some drillers viewed that as being a cost-free royalty. But in light of what we were seeing in 2020 here in Pennsylvania and now Bluestone, I think that position, that argument, that theory is going to be challenged by drillers going forward. So again, be mindful if you have a lease that has in the pipeline language or similar language, and your driller has not been taking deductions, that might change in 2021, and keep an eye out for that change. Next slide. I'm going to turn the presentation over to my friend and colleague, Brendan O'Donnell. He's going to talk about Young versus Ecuador, USA, and then also he's going to take up the issue of the consent and the consent to assign issue that's been emerging here in Pennsylvania. Brendan?
Thanks. Hopefully everyone can see and hear me, as hopefully there's no technical glitches here. So the next case in the presentation is Young versus Ecuador, USA onshore. As Bob noted in the introduction, it is not a Pennsylvania case, but it does have some interesting points for Pennsylvania landowners, and to the extent that anyone on here has property in West Virginia, it's certainly applicable there. So as a bit of general background, this particular case involved about 70 acres in Ohio County, West Virginia. The lease had a fairly descriptive royalty clause that identified that the royalty rate was 14% of the net amount realized by the lessee computed at the wellhead. And when in Bob's discussion of the Bluestone case, you know, the wellhead has a legal significance. You know, the lease, then it went on to describe what net amount realized by lessee computed at the wellhead means. And it said that means, you know, the gross proceeds minus post-production costs incurred by the lessee between the wellhead and the point of sale. And it listed a whole variety of different types of post-production costs, you know, such as separating, treating, compressing, metering, things like that. The list was very extensive in the lease itself. The landowner, the Youngs, their primary argument was that even though the lease royalty clause said at the wellhead, that deductions were not authorized under the Tawney versus Columbia Natural Resources case. So West Virginia is interesting because there are two cases that are still good law in West Virginia. The Wellman versus Energy Resources decision, and then the Tawney versus Columbia decision, that are probably the most royalty owner friendly decisions relating to post-production costs in the country. And they basically require the lessee to undertake and incur all post-production costs until the actual point that they go and sell the gas. Those cases have been in question in recent years after the West Virginia Supreme Court of Appeals decision in Leggett a couple years ago regarding certain flat rate royalties and the application of a statute, but they were never overturned. Federal district court cases from West Virginia since then have indicated that Tawney and Wellman are still good law in West Virginia. This Young versus Ecuador case actually is a decision by the U.S. Court of Appeals for the Fourth Circuit. So as Bob described earlier, associated with the way that Pennsylvania courts work, trial courts in West Virginia in the federal level, appeals there go to the U.S. Court of Appeals for the Fourth Circuit. It's a federal court, so it doesn't make state law. And what it does is it can only apply state law as it exists. So with that background, the Youngs argued, look, here in West Virginia, Tawney sets forth a three-pronged test in order to determine whether a lease actually allows you, the driller, to take deductions. First, does it expressly require us to bear post-production costs as the lessor? Second, does the lease particularly identify the specific deductions that the lessee, the gas company, intends to take? And then third, does the lease indicate the method for calculating the deduction for the post-production costs? If any of those criteria are not met, the argument went, then under Tawney, no deductions were allowed. In this particular case, the real focus was on the third issue of the Tawney test, whether the lease indicated the method of calculating the deduction of the post-production costs. The federal trial court in West Virginia, it agreed with the landowners, and it said that there wasn't a mathematical formula in the actual royalty provision that would identify an actual means of calculating the post-production cost that would be deducted. That approach is very favorable to landowners, and it requires a degree of specificity in the lease to say exactly, not only what are the post-production costs, but specifically identify how they can be deducted. It was appealed up to the Fourth Circuit, and the Fourth Circuit reversed the federal trial court's decision. The Fourth Circuit, in probably a bit of hyperbolic language, it said that the Tawney decision and the third prong doesn't require an Einsteinian proof for calculating post-production costs. And the reasoning of the Fourth Circuit Court of Appeals was that the royalty clause identified the net amount realized at the wellhead. It identified a variety of different post-production costs that could be taken, and that if you were to go through the usual analysis of calculating what your royalty would be, that would allow you essentially to have a formula to determine what the post-production costs could be to come out of your lease. So it doesn't say, A plus B equals C in the actual lease. The court said that's not the standard. The standard is more, is there an easy and readily identifiable way for you to determine the post-production costs in order to calculate what would actually be taken out of your royalty? And the Fourth Circuit reasoned that, yes, that existed here. And then, similar to other cases recently, it left open a question of, what really is the law in West Virginia? Now, are Tawney and Wellman still good law, or is there still a cloud hanging over them, which has been the case for the last several years, but notably, neither the West Virginia Supreme Court of Appeals has taken it back up, nor has the West Virginia legislature. So, while it's not unexpected that happened, that the court made reference to that, it's at least something to note, given Bob's point that, there seems to be at least indications of a movement in the driller's favor. And when you have a federal appeals court questioning whether state law actually is state law that's beneficial to landowners, it's probably something to take note of, even though it's in West Virginia, because it may indicate a generalized feeling, within the court system about, the balance between lessors' rights and lessees' rights in specific leases.
Before we go to, I just want to add, there's for a moment, Brendan, Pennsylvania, we wouldn't fall under the Fourth Circuit. Our federal appeals go to the Third Circuit. But as Brendan was saying, West Virginia has some of the most pro-landowner post-production cost law in the country. And to the extent that law is being eroded or diluted, that's what Brendan and I are concerned about. That could represent a growing wave of cases that are more pro-driller as opposed to pro-landowner. Because if they're eroding West Virginia deduction law, how does that play out for everyone else? But I just wanted to interject. That's why we're talking about Young, that it may represent a growing tide very close to our boundaries. Sorry, Brendan, go ahead.
So from that point, certainly Young is a case worth noting for anyone with property in West Virginia. It does not change West Virginia law because it's not a state court decision, but it is certainly something that any court, whether it's a state court or a federal court in West Virginia, would look to as carrying some degree of weight, and also courts in other jurisdictions like Pennsylvania right next door. Although it's not in the same federal circuit, the fact that a case arose to a federal circuit court level always has a bit of cachet for whatever court looks at it. So a couple takeaways from this case that tie into Bluestone. Aside from questions about whether Tawney and Wellman are good in West Virginia, the netback calculation method. Bob talked about it in connection with Bluestone, and where the court there sanctioned, the netback method to calculate the royalties to arrive at a wellhead value. In Young, it also discussed use of the netback method. The concept is that the netback method is a way of calculating a royalty that takes the ultimate price received wherever the gas is actually sold, and then deducts the cost between the wellhead and that location, with the theory that the value of the gas at the physical wellhead is equal to what the gas is worth sold when it is sold downstream, minus the cost to get it there. And part of the reasoning underlying the netback calculation method is that when gas moves, the costs of moving gas are relating to the differences in value. So a theory would be that if it costs 50 cents to move the gas between point A and point B, that should be reflected in the value of the gas between those different points. The problem with the netback method that we've been seeing, and that I think Bluestone and Young hit on, is that it seems that courts may be too quick to apply the netback method to actually determine what the value is of gas at the actual well pad. So the third point here, which I'll tie back into that concept, is the 2009 lease at issue in Young. It actually defines in the lease document net amount realized by lessee. And it says, that shall mean the gross proceeds received by lessee at the point of sale minus post-production costs. The take-home message in part is that royalty owners should actually take a look at the lease to get a sense of what the royalty is supposed to be calculated on. There should be specificity in the lease about that topic. And it should not be assumed that certain provisions or statements or clauses in the royalty section of a lease just blanket allow deductions of post-production costs. There may be deductions from the royalties, and drillers may want royalty owners to believe that deductions are authorized. But it really requires actually taking a look at what does the language of the contract actually say with respect to the volume of hydrocarbons or the value of hydrocarbons that my royalty is based on. And the fact that this lease in Young, it actually defined what they meant when they said net amount realized by lessee. It indicates that there's not a singular simple definition of what certain terms and concepts mean. So while drillers may suggest things that there's always a term of art or a custom of use, the fact that concepts like net amount realized by a lessee was actually defined in great detail in this lease cuts against that argument. So that is a takeaway that I think everyone should be mindful of. Take a look at what you lease. Take a look at the lease, see what it actually says, and see whether the royalty statements reflect that. So getting back to what does the lease say that the royalty is based on? If indeed the royalty is based on the value of gas at the wellhead, the netback method is not the exclusive way of figuring out what gas is worth at a well pad or a wellhead. In fact, there's commentary that suggests that the netback method is to be used if there's not another good calculation method sometimes. So there could very well be situations where companies are actually selling gas in close proximity to a well pad, and they may be selling it for far greater value than either that company or another company with the well pad next door is selling gas for by moving it out onto the interstate pipeline. And therefore, the view that gas at the well pad or the wellhead is necessarily worth what it sold somewhere else, minus the cost to get it there, that's just a derivative calculation. All that tells you is that you sold this gas on the interstate pipeline in location X, and it cost you $1 to get it there. It doesn't mean that gas, whether good, bad, or otherwise, is actually worth the difference from the subtraction formula at a well pad in Greene County or Washington County or Sullivan County or anywhere else. It simply tells you what it's worth somewhere minus the cost. In a perfect marketplace, that may be true, but many of you may have come across situations where not every sale takes place in that marketplace, and there could be, and not necessarily that it's good or bad for royalty owners, but there are other data points to figure out what gas is actually worth at whatever point of calculation is determined in the royalty. And just reflexively going to the netback method as the cure-all approach, we think is problematic. And it's one of those things that the Kilmer decision that Bob had referenced, about a decade ago, for a long time, it was almost viewed as a carte blanche blanket allowance in Pennsylvania for deductions of post-production costs. And then there is more of a focus on what does the language of the lease actually say. And that's where our position is still, what does the language of the contract say? And let's enforce the language of the contract versus just a blanket view of the wellhead being calculated by, wellhead value by the netback being the end all be all. So that's certainly something to take a look at and to see the approach of courts, arbitration boards with respect to what does the language actually say, and let's give that effect versus just reflexively going to a different calculation method that the industry may promote. The final case for this evening is a bit of a different tack. It's something that we really haven't covered in a while, and one of the reasons we haven't covered it is the law on it is developing, and it's a topic that you would think the law should not really be developing on. So this is Mayo Foundation versus BP America. This is from Texas. It is a federal district court case. The Mayo Foundation is related to the Mayo Clinic. And in terms of cases that lawyers read, cases they're black and white or partially obscured by this backdrop. A lot of them are not very exciting. This particular case, the discussion from the Northern District of Texas Federal Court Amarillo Division was actually an interesting break in the standard cases that we read, because it told an interesting story of gigantic ranch lands in the panhandle of Texas that were, almost the size of Rhode Island. And it kind of gives you a flavor of, okay, well, to the reader sitting here in Western Pennsylvania, all right, I get a sense of what we're talking about. And so where does this case go? Well, it's a 1994 lease that actually the lease originated, iterations were before this one. And there was a restriction on the ability of the lessee, the gas company, to assign or to transfer its rights in the lease. And the original iteration of the lease provided a blanket restriction on the lessee's ability to assign it. And then that was modified by several amendments, and it ultimately wound up with a provision that the rights and obligations of the lessee, the gas company, are not assignable except upon the written approval of the lessor, which shall not be unreasonably withheld. So what happened was that the rights in the lease were assigned. The plaintiff, the lessor, objected to that assignment, but nonetheless the assignment went forward. So a lawsuit was filed, and there was a variety of introductory filings that got down to the substance of the case pretty quickly. The plaintiff's primary contention was that the assignment that occurred was objectionable because the plaintiff, the lessor, had prior business dealings in litigation with the assignee, the party who took the lease from the gas company. Another interesting fact, which it's unclear how much this played a role in the court's decision, was that the lessor had its own preferred assignee, which was a company that it had an interest in itself. So it preferred that the lease be transferred to someone else that it partially owned. That didn't happen. The landowner objected. BP defended, saying, look, the consent to assign was not really legally required, and we went forward and we assigned the lease. There's nothing to see here. There was a preliminary injunction that was filed that moved the substantive issues to the forefront, because what the court took a look at was when an injunction was requested, it looks to the probability or the chances of succeeding on the merits. So instead of going through years of litigation, it actually was able to move quickly on, all right, what are the issues here? What is their impact? What is the probability of success dealing with this objection to the assignment clause? So the issues before the court was paragraph 7 relating to the assignment, an unlawful restraint on alienation, and secondarily was the landowner's refusal to consent reasonable. A bit of legalese on an unlawful restraint on alienation. Alienation is simply transferring or granting rights in property to someone else. And generally speaking, the law, in quotes, disfavors restrictions or restraints on someone's ability to transfer real estate. So the first question the court had to tackle was, did this lease kind of violate the general concept in the law that you can't transfer that it should be very limited what restraints you can put on transfer. And second, was the refusal to consent actually reasonable or unreasonable in this case? As a bit of a spoiler, the court found that the withholding of consent was not reasonable, but the court identified a variety of factors that it thought would be useful. And this is where it gets into a Pennsylvania-related discussion, because the court, it cobbled together these different factors. The assignee's solvency and their track record of making royalty payments, their industry reputation, prior working relationship, their capacity to work as an operator, and whether they're just a lease flipper who's going to send it to someone else. It cobbled together those concepts from a variety of different sources. And one of the things that the court was wrestling with was that Texas law on the concept of restrictions on lease assignments was not developed. You would think that somewhere like Texas that has had decades and decades as probably the foremost authority on oil and gas law, would have a well-developed body of law on restrictions, requirements on gas companies' ability to transfer and assign rights and leases. The court really said, we're kind of operating in a gray area here. So these are the factors that we think are reasonable to consider. And generally, I think that these are reasonable things to look at in terms of the ability of a royalty owner or lessor to object to assignment if your lease allows you the ability to consent. And usually that's conditioned on that your consent cannot be unreasonably withheld. So with these factors, it doesn't say that one of the considerations about refusal to consent is that you don't like the gas company. These are, more objective type criteria that can be reviewed. Solvency can be determined based on financial statements, track records involving royalties. You can do a search to see if a company has been sued for serially not making royalty payments. Industry reputation, that's more of a feel-good type thing, because everyone's view of a company is different, whether they're a competitor, whether they're not. Prior working relationship, I think, is reasonable because that's a direct first-person interaction where you can credibly say, yeah, I've been on the other side of a contract with this company, and they have not, they've not made payments, they've not operated well, things like that. The capacity to operate a lease is another provision, and it ties into whether they're a lease flipper. Is this just a paper company that's looking to put assets on the books to sell and make money? Do they actually have capital to drill wells, to produce gas? Do they even have the ability to, negotiate contracts with some degree of, bargaining power with a gathering system to be able to move gas? Or are they just at the mercy of someone else who's much bigger than them and can dictate terms? For example, if you are at the mercy of signing a gas gathering agreement to move your gas from a well pad to an interstate pipeline, those gathering costs are a significant chunk of post-production costs that landowners see in their royalty statements. So if you're a big company, theoretically, you might have the capital, political and otherwise, to negotiate a good agreement where those costs are minimized. But if you're not, it could cause a problem and result in more cost to both the lessee and the lessor. So those are all concepts that the court identified, as things that are relevant here, associated with the ability to refuse or grant consent for assignment. So where does that take us for Pennsylvania? Pennsylvania is probably the oldest oil and gas jurisdiction in the country. As Bob mentioned, the rule of capture started here in the oil and gas context. Like Texas, though, Pennsylvania is not entirely clear on consents to assign oil and gas leases. And this is probably going to continue to be a significant issue going into 2021 as the COVID effects shake out, as there's probably going to be more consolidation within the gas industry. There are, and there's still new leases that are being negotiated and signed. So what is the viability of existing clauses that require landowner consent to assignment of leases, and is it worth putting those provisions in newly executed leases? It's unclear in Pennsylvania. There is somewhat of an interesting technical issue in the law, in that Pennsylvania and other jurisdictions view an oil and gas lease as being two components. Number one, a contract, and number two, a transfer of a real property interest in the land. And those are things you often see in cases, but there's not there's not usually a description of what that actually means. So it causes a wrinkle, because there is legal authority in Pennsylvania in the landlord-tenant context that if a clause says you can't assign, it means what it says, and there isn't even a requirement of reasonableness if you say no. So if you have a commercial lease and the lease says, look, you can't sublet this or assign it without my okay. Now, there's some cases in Pennsylvania that says, yeah, you can just say no and say no. But that's in a landlord-tenant context. It's a contract, but it's not an oil and gas lease. There are sometimes parallels that landowners try to draw between the the landlord-tenant context and oil and gas leases. Courts usually say, look, oil and gas is its own species, but there are, it's not entirely unreasonable to make that suggestion, because oil and gas leases do have that contractual element. The Mayo Foundation court got to the point of, look, the lease transfers an interest in real property to the lessee, and therefore that is why the property right subject of we don't really want you restricting the ability to transfer it comes in. There are a couple, there's no specific case that we're able to find in Pennsylvania that says loud and clear, this is where Pennsylvania courts stand. Our view is that, consent to assign provisions in Pennsylvania, that have a reasonableness requirement for consent to be withheld are probably valid. There's a federal court case from about 10 years ago that it didn't get into the issue, but it said, if a lessor desires to restrict the assignment at the time of execution of the lease, the lessor can mandate that no assignment occur without its express consent. That case, so it says, no, you could do that, but it doesn't further get into those details. And that particular case, going back to the landlord-tenant example, becomes somewhat interesting because the actual issues in that part didn't deal anything with consent to assignment, but it dealt with who is responsible for different breaches at different times. And there are interesting questions about whether concepts of responsibility under landlord-tenant law, in terms of you breached the lease. So if you transferred it to someone else, you can't give someone else your liabilities. You're responsible for it. The court actually looked at those concepts as a federal court decision, and unfortunately it was sent to state court, so there wasn't a great elaboration on it. But it reveals that the law is not entirely clear. Getting to, a final point is there is a distinction in the law between an assignment and a merger or an acquisition. And there is a Pennsylvania court case, Pennsylvania Superior Court case back from 1993, Santa Fe Energy Resources versus Manners. And in that particular case, it was a royalty provision. It had it was a lease that had an assignment provision that required certain assignments to gain the consent of the landowners. And what happened there was a company essentially was, there was a merger and acquisition, and the lease ultimately changed hands. And the royalty owners sued and said, look, no one consented, no one obtained our consent. So this can't go forward. And the court said, look, this was a product of a merger. It was not an assignment under the lease, so therefore it can go ahead. That decision is notable, getting back to the general overarching comment that you would think that there would be law directly on point. But here the court had the opportunity to say, look, we believe that, the consent to assign clause that's in this lease was against public policy anyway, so it wouldn't even be enforceable. Or it could have said, yeah, you know what, you can do this in Pennsylvania in a lease. But the court completely sidestepped that issue and just said, look, there wasn't an assignment, end of story. So it leaves it open to, can this be done? Is it actually done? Is there a utility to, negotiating these consent to assign clauses in leases? There may be. It depends on the other provisions in the lease. It depends on the operator. But probably the biggest takeaway message is, getting back to the theme that Bob had talked about earlier and I touched on is, the place to mean what you say and say what you mean is in the text of the lease. Don't rely on this operator is good, I trust them, they're not one of the bad guys, or this operator is a bad guy. Specify it in the lease so that way the terms that you agree to carry on no matter who gets it. It may be reasonable that you want to make sure that a responsible operator is the only one assigned your lease, but draft provisions into a lease that capture whatever your preferences are, so you're not relying on a court's different factor test of industry reputation and things like that, that could have a significant impact on how you get paid.
Thanks, Brendan. We're just about at the end of our program. I wanted to add, with respect to the consent to assign, I think this is going to be an emerging topic in 2021 as we continue to see consolidations and companies transferring assets. It's going to be an issue that's going to get litigated, and we will probably get an appellate case providing some more guidance. But the Mayo Foundation case at least provides a roadmap of how we may want to steer these cases and that checklist of criteria. So we appreciate you attending tonight. We hope you got some value out of the presentation. We'll try to do another one of these virtual town halls in the spring, unless the COVID situation alleviates and we can actually come out to your community and meet face to face. In the meantime, thanks again, be safe. And if you want a copy of the presentation, it'll be available on our website. Thank you and have a good evening.